Now today it is my distinct pleasure to introduce Professor Mike Kagan. He is currently Joyce Mack Professor of Law at the William S. Boyd School of Law of the University of Nevada, Las Vegas. He's a leading scholar in international human rights and refugee law, and also administrative law and professional responsibility. Those are the subjects that he teaches and practices. He also leads a UNLV immigration clinic. He's the director of that clinic, and he's active both in his academic endeavors as well as clinical activities. And his opinions and arguments have been published widely in leading law review journals, as well as some media outlets such as Washington Post, Daily Beast, Salon.com. And those views of his have shaped the debate, legal discussion around the issues of immigration and refugees. So he's been very influential as a leading legal mind on this issue. He's also been active. He's been on the front lines fighting the battle of immigration and providing legal aid for underserved people from many, many corners of the world. So he is somebody who knows a lot, both in terms of legal debates as well as sort of practical impact of especially the current administration's efforts to curtail immigration and flows of refugees. Okay. So we are very delighted to welcome him to speak on this topic. So please join me in welcoming Professor Mike Kagan.
Thank you very much for that introduction. I was really happy to be invited to come back to Ann Arbor, where I went to law school, and to talk about a topic, the topic of immigrant rights, which is now at the top of many people's minds. It was a much more marginal topic for most of my legal career, and certainly was when I was in law school. There are still law schools in the United States that don't have a permanent faculty member who teaches immigration law. I remember when I first moved to Las Vegas that I would talk to lawyers in town, very established attorneys, and who would ask me what I taught, and I would say immigration law, and they would sort of furl their noses and say, I don't touch that. Now it's unfortunately of interest to many people, and from very bad reasons, but maybe at the conclusion of my talk, I want to talk about how we can make the most of that to actually improve the situation that we're in. I am going to, just to be clear, when I talk about immigrant rights, I'm going to be very informed by two things. First, the fact that I work in Las Vegas, and the UNLV Immigration Clinic is the only provider of free attorneys for people in deportation defense in the entire state of Nevada, and particularly in the city of Las Vegas, which I'll talk about, which is one of the most diverse cities in the United States with one of the largest immigrant populations, and as I'll explain, one of the least defended immigrant populations inside the United States. I don't work at the border, and much of what has been in the news about immigration policy in the Trump era has been at the border, and I think that's important for a number of reasons, but that's largely what has been most visible. And I'll be talking a lot today about what is invisible and why that's important and why it's troubling to me. The other experience that's going to inform my talk today is something that I did right after law school here. I typically tell people that my job as a professor at UNLV is the first normal job that I've ever had, and I'm glad I've been able to hang on to it this long. But when I took my last law school exam, I got on a plane to London and essentially didn't come back for 10 years. I went to the Middle East. I was a trailing spouse, and while trailing, I worked in setting up refugee legal aid, especially in Egypt more than any other country. And I also worked in Beirut and in Jerusalem, and then finally in Dubai, and before coming back for a job interview and then a job in Las Vegas, a city that honestly I had no interest in going to whatsoever. And I'm still there, and it has been an immense privilege, especially I have to say the last few years. But I know that the title of the talk was specifically about Trump immigration policy, I am going to talk about why, to me, it seems that our legal system seems so inadequate to the task of what we might need it to do, given, I think, the racially motivated cruelty that is being inflicted on immigrants, both at the border and inside our communities, inside the United States. But to get to that, I actually want to reflect on something I actually have not had a lot of chances to talk about. The way in which what I saw in the Middle East informed my perspective on what's going on in the US, and why increasingly I have a sense of deja vu, not a good thing, given the countries that I worked in what I am seeing in the last few years in the United States, and what lessons I think that might offer for us about where we are failing, where our legal system is inadequate, and what we might do about it. So let me start by talking, I'm going to focus especially on Egypt, because it's the country actually that I lived in the Middle East that's closest to my heart and where I worked the most. I taught at the American University in Cairo. It was really my first teaching job. But actually more than that, I worked in developing refugee legal aid. I was the director at an organization called AMERA, Africa Middle East Refugee Assistance, which no longer exists. And it no longer exists because of some human rights problems in Egypt that I'll actually mention. So why is it that Egypt seems to me to have prepared me quite well for what I see going on in the US today? There are some reasons that are that should be obvious, I think, to anyone who reads the news, including today and the past week or so. The way in which there's a merger between the person of the leader, of the president, and in terms of his both personal interests in terms of money and business, and the use of the state to pursue one man's political interests rather than the interests of the country. We're seeing that line cross and that merger right in our face recently in the last few weeks, and that's very familiar from Egypt. That's certainly at the time I lived there, that was the case of the Mubarak family. The use of division and demagoguery. So in the Arab world, it's pretty normal in political rhetoric for the government or to refer vaguely to some foreign interests, and everyone is supposed to know which foreign interests we're talking about without having to actually name them. And now in the US, you have similar kind of rhetoric, whether it's elites, the media, immigrants, racial resentments, and some shadow anti-Semitism that's resurfaced in a way that I honestly never thought I would see in my lifetime in this country. The use of conflict and chaos. It's been often observed that autocrats need conflict, they need an enemy. They need some danger to make themselves necessary, because otherwise people might have the luxury of thinking about reform. And we hear this now. President Trump actually sometimes has even said at rallies that you have no choice but to vote for me. And he doesn't actually literally mean that you don't have a choice over who you vote for. He literally means that the other side is so scary that even though you might not like me, that you have to take me. And that logic actually is what has led to surprising support for monarchs and dictators in the Middle East, that this would be total chaos here without the strong man. I alone can fix it, in other words. Also, questionable election mechanics. Now, I don't want to exaggerate the case in the US, but we clearly I don't think anyone, if setting up a new election system for a new country, would necessarily come up with the one we have in the US in any number of respects. And that's not unusual. Ways I'll come back to. A lot of countries I lived in held elections, very problematic elections, but they did hold them. Finally, the conscription of the government's data sources. The government is often in our society is a necessary source of information about anything that's going on, any policy concern, and the conscription of the government as a data source into serving the political leaders' rhetoric. When I first went to Egypt in 1998, I came across a report about HIV in Africa. And this was been from the late 1990s. And the number of confirmed, according to the government, and thus according to the United Nations, the number of confirmed HIV cases in Egypt was 0. Now, that's ridiculous. Of course there were people with HIV in Egypt. There must have been. There were people with HIV in every country in the world. But it was a lot easier for the government to say it was 0, because then you don't have to have an HIV policy. It's a problem for other countries. And of course, we have seen shades of this. Now, that's kind of data. How many people have HIV? That's something that, HIV policy is something that ought to be debated by elected officials and politicians. But you debate it from the facts you get from the Centers for Disease Control. But we now see in the US that most famously recently, the Sharpie map and the politicization of the National Weather Service. Now sounds like a joke, but it's no joke because it was made into a joke because it was so flagrant and in many ways absurd. But that's deeply threatening because it's one thing to debate climate policy. It's another thing to debate whether a hurricane is actually happening. And it's not just that. There's other things that that don't get the attention of late night comedians in the field that I work with. The Executive Office for Immigration Review, which runs the immigration courts in the United States, has put out statistics that are very obviously misleading, but that feed the White House's rhetoric. For example, about how many families who've come through the border miss their immigration appointments, immigration hearings. The government has been saying that 90% of them miss their hearings. That's not true. It's actually the opposite. 81 to about 87% show up for their hearings. What the government has been doing is looking at the number of cases closed and the number of cases closed in of recent arrived people. 90% of them were in absentia orders. Now that's not surprising. People who don't show up get their cases closed really fast. Because of the backlogs in the immigration court, the other people's cases are still pending. So this is a flawed data point in a number of ways. Now politicians spin data and use statistics to mislead all the time, and it wouldn't be so alarming if it came from the White House. But the fact that it actually comes from the Department of Justice, and not just the Department of Justice in terms of the political appointee, the Attorney General, but from the specialist division, the Executive Office for Immigration Review, that means, well, where are we supposed to get information from, right? If we can't depend on those agencies to provide a clear statistical portrait. So all of these things are visible trends in the United States. I don't want to overstate the case. I don't think that we are as far down the road to autocracy as Egypt was when I lived there, or even more now. It's actually worse now than it was then. But they're all phenomenon you can see here, and they are key ingredients to what's going on there. And they're pretty obvious on the front pages every day now in the US. But that's not what I want to stress for the rest of my talk. What I really want to actually stress are some more nuanced and subtle things that I learned about how autocracy can work when I went to work in Egypt that I didn't understand and that were a lot less obvious to me. And as a lawyer who had some romantic ideas, and I deliberately use the past tense there, about the role of lawyers and the role of law, it's these more subtle issues that I think have become much more disturbing to me and that I've been thinking about much more recently. And they have to do with the machinery of repression and how it's often really boring and tedious and hard to explain and technical and involves a lot of lawyers. So let me first of all, the last place I lived, as I mentioned, in the Middle East was Dubai. Dubai actually, although it's very modern and Western in outside appearance, in terms of government is actually a lot easier to understand. It fits, I was taught, I remember in elementary school, they taught us basically that in the world there were dictatorships and democracies. Actually back then there were communist dictatorships, regular dictatorships, and democracies. Those are the only kinds. That's the only 3 types of government you can have, according to, I think, my 3rd grade teacher. So my apologies to Mrs. Hyde. And in many ways, to be honest, I'm probably embarrassed to say that even when I was still, after my first year in law school here, I think I still had some of that framework in my mind when I first went to actually work in Egypt, and it didn't equip me. It would have made it very easy for me to understand Dubai, which is a monarchy, right? And so when you drive on the highways in Dubai, there's a picture of Sheikh Mohammed and his sons. The Sheikh and his sons. No question, that's the government, right? It's right there. And they don't pretend it's anything but an emirate, a monarchy. And it's very clear that you can have any kind of law there and it'll be implemented, but it's whatever law the Sheikh says the law should be. So it's actually, Mrs. Hyde in 3rd grade prepared me for that kind of government. I had a framework to understand that. That was basically what I understood that was the King of England in the Revolutionary War. Essentially, same idea. But it doesn't match, and actually Dubai's a fairly open monarchy in the sense of its economy, but essentially you had the same thing in some much more brutal dictatorships like, say, Iraq under Saddam Hussein. Was not a monarchy, but it ruled in a very thuggish, brutish way without much pretense of being anything other than a dictatorship. And that also, although I never lived there or visited, but that also I think I had a framework to understand. Egypt was something different. Egypt, no one ever thought that it was truly a democracy, except the Egyptian constitution says that it is. It says it's a republic, and its leader is a president, not an emir. And there are elections, and there's a parliament, and there's elections for the parliament. And in fact, at that time when I came, there was even a relatively free judiciary, which had actually invalidated the elections because they were flawed, and had invalidated any number of laws that the Egyptian government had passed. So it had a lot of this machinery that, wow, God, that sounds like us actually, right? We have a Supreme Court that overrules laws too, and this is not what I was prepared for. In fact, the Egyptian constitution, while hardly a perfect model, this is the 1971 constitution, the one I started reading when I went there in 1998, has a Bill of Rights and a pretty impressive one. It says things like, all citizens are equal before the law. They have equal public rights and duties without discrimination due to sex, ethnic origin, language, religion, or creed. That's Article 40. It prohibited torture, and it even had, for the lawyers in the room, the exclusionary rule. And a confession extracted through mistreatment of a prisoner would not be valid in court. That's not even all Western democracies have that rule. It required a judicial warrant before the government could invade someone's home. It guaranteed a right to privacy. Our constitution doesn't have that. Not explicitly, the Egyptian constitution did. That's Article 45. Had freedom of opinion and freedom of expression as separate items. We have them all compressed into one, and it takes us a lot of legal briefing to figure out what they mean. And very important for me, because I was working with refugees, there was actually a right to political asylum for foreigners in the Egyptian constitution, Article 53. Our constitution doesn't have that. So it's a really pretty impressive document in many ways. There are many problems in it. There's a lot of difficult ways that the rights of women were described and some things that are balancing. I'm not trying to portray it in idyllic terms, but it's a serious legal document which, if applied, actually would possibly produce a fairly interesting and fairly democratic government. Again, not a perfect document, but nor is our Constitution a perfect document, as I think we are learning on a daily basis. When I got there in 1998 as a law student, I had taken torts and contract law. I had not even taken international law, because I'd only done 1 year of law school. My wife had a fellowship, and I took a semester off, and I went to Egypt for 7 months. And I had an internship at a Egyptian human rights organization, and I walked into this dusty office and sat down in a place where there's no air conditioning. We arrived in the summertime. People came and offered me tea but spoke no English. I spoke no Arabic. I was a typical American. This was sort of my first very, very necessary awakening to the idea that as a privileged American, I might not have all the answers. In fact, at my first morning there was I had a panic. What exactly would my use be, and why in God's name did they give me an internship? Because all the lawyers who came into the office first didn't even speak English. They offered me really strong tea with the grits on. I learned to drink super sweet tea with the grits on the bottom, and that was how they said hello, but I was really lost. finally, the person who became my first real mentor as a lawyer, an amazing human being, unfortunately has passed away, a political dissident, Ahmed Saif al-Islam, who's a renowned figure in the Egyptian human rights movement, walked in. He became my teacher. He also fortunately spoke English. Most of the people there didn't. And he explained to me that afternoon why I was there. Because of the way the Egyptian constitution was structured, because it's declared from the beginning that Egypt is a republic and is going to be democratic, they could challenge laws in their constitutional court the same way we challenge laws in our federal courts. And to interpret their laws, the Egyptian Constitutional Court had said, well, we want to know if it is consistent with the norms of democratic societies. And my job, evidently, having taken first-year torts class at law school here, was to help tell them what are the norms of democratic societies. This was pretty intimidating, but it sounded really fun, and I spent a lot of time there. This was in 1998, so there was beginning to be legal information that you could get on the internet on a dial-up connection in Cairo, but not a lot. I spent a lot of time at the British Council Library, at the Indian consulate, because they were very interested in non-Western democracies. That would be much more, you didn't want to go into an Egyptian court and just be talking about what they do in the US and Switzerland. If you could say this is also what they do in India, or very usefully at that time, the newly democratic South Africa, which also has a really good constitution and one that they're a little bit more serious about applying. Those were the best examples to kind of apply. Now there are things, the idea of the norms of democratic societies is kind of an interesting one, and I had a great law school seminar after this here trying to figure out what's sort of the baseline of human rights. And there are, in areas like, say, free speech, there are famous debates. So like in the US, hate speech is protected. Most Western democracies it's not, right? So that's a great topic, and that was the kind of thing that I think I would have been most prepared for and could have more easily to explain to my parents what I was working on when I was in Egypt. So what's like the minimum of free expression? But that is not what Ahmed Saif wanted me to work on. What they needed me to work on, what was actually a much more pressing concern for human rights in Egypt, was freedom of association, and actually in more tedious terms, registration of non-government organizations. That's not very exciting. So I appreciate all of you staying in your seats and not getting out to leave. So there's, again, to go back to that 1971 Egyptian constitution, there's an article, Article 55, citizens shall have the right to form societies as defined by law. That's essentially the protection to form nonprofit organizations. But you have to register your organization in order to function. This had to do, basically, it looks and walks and talks a lot like applying for nonprofit registration in the US, or to set up a nonprofit organization. You can download the forms for that on LegalZoom. Basically, same idea. Like it's not foreign to the United States to think that you should register a nonprofit for a number of reasons. And there were tons of non-government organizations in Egypt, a thriving civil society in many ways. In fact, there were many human rights organizations. But the human rights organizations had trouble getting this registration, and that is what I was assigned to work on. They would sometimes actually get a no, as in you can't register, but more often the government would just not answer, right? So they would send in their application to register, and then they would not get any document back. They wouldn't get their stamp, and they wouldn't get a yes, and they wouldn't get a no, but this was imperiling to actually be able to work, because without that yes, you're registered now, you can't open a bank account. And when you go to European donors who are used to their system are wondering, why don't you have a proper nonprofit registration? We can't give you money. Go get the paperwork and come back. Why don't you just get the paperwork? You must be lazy. That is the issue that I had to work on. And I realized by looking at that, this was brilliant for the Egyptian government. What they had figured out is that if you sent the secret police in to raid a human rights organization and arrest all of its employees, that ends up in the Western news. That becomes a headache with the annoying ambassador from Sweden who will come and say, well, now our aid to your country is imperiled because you've endangered human rights. But they realize we can actually quite successfully control the human rights movement through paperwork without having to arrest anyone. No use of the secret police. Same with needing government approval to receive foreign donations. There's not a lot of philanthropy, especially in the human rights field, in Egypt. So human rights groups depend on donations from the Ford Foundation and from Europe, but that's foreign money. Egypt, a post-colonial country, constantly an animating feature of Egyptian politics is the fear of foreign meddling, would say, well, we need to look at any foreign money coming in. And that seems really repressive if we know, like, well, what's wrong with getting money from the Ford Foundation? But think about the US today. If you had new nonprofits being set up with millions of dollars flowing in from Russia, would it seem so unreasonable for someone in government to say, hey, you know, that should be approved first, so that we make sure that these groups are not serving a foreign interest? It's not so foreign, this concept. But of course, it's also very useful there to repress civil society. What I learned from seeing this, I won't bore you anymore with my internship from 1998, but I want to highlight what I learned from that there's a lot of power in the machinery of government that's out of sight and hard to explain. It's taken me a lot of words just now to explain it to you. And a smart dictator knows how to use that power first before they send the secret police in. And they basically use the machinery of democracy against itself, right? Because they're using things that, we have that too. We have nonprofit registration too. So does Europe. And so the Egyptians could say to any foreign interlocutor, what we're doing is the same as what you're doing. Why are you complaining? And in a narrow sense, it was defensible. Each individual decision or non-decision could be defended because they had lawyers working on it. And that was a disturbing revelation, because I had this romantic idea of lawyers as being a force for justice, right? But then I realized the autocrats have lawyers too, and a lot of them. And in fact, who are these people? Well, to be blunt, and this is not very politically correct to say in the legal profession, I met many of these Egyptian government lawyers and prosecutors, the same prosecutors who sign off on the imprisonment of dissidents. And they reminded me a lot of people I went to law school with here in Michigan. Not because I'm saying my classmates have put a political prisoner in jail, but because their motivation was to do what's prestigious. And what is prestigious? Get a job in the Department of Justice or the Ministry of Justice. Be a prosecutor. Serve your country, serve your community. This was a high status job, and it's respectable, and then you're trained, this is what we do. And beyond the fact that, yes, I might have some concerns about this, but I am just enforcing the law, right? I'm just enforcing the law. And that's another disturbing thing, the fact that rule of law and justice and freedom are not necessarily the same thing. When we get the law right, they merge, but they're not inherently the same thing. Now, this should not have been a surprise to me or to anyone else. The apartheid in South Africa was law. It was written by lawyers, it was legislation, it was a whole bunch of court decisions, it was a legal system. The Nuremberg laws were laws, right? So that should become of no surprise. But the fact that the authoritarian nature of Egypt was actually being enforced by well-dressed people who were well-educated, many of them had spent a year at Columbia or something, and now were working for the Egyptian prosecutor, that was a shock to me, and I didn't understand how that could happen. And they wouldn't say, I want to repress this human rights group because they criticize the president. They wouldn't talk like that. They would say, we have to follow our laws, just like your government has to follow its laws. And that's our law. I realize our law might not be perfect, but we have to enforce the law, don't we? So that's quite disturbing. But there's something else which really echoes quite a lot to me now, which is the way in which these mechanisms that the Egyptian government would use were narrowly defensible. If you looked at the big picture of what was going on, it was very obvious that this was a sham, right? The same way the Egyptian elections were a sham. If you wanted to form a soccer club, your NGO registration would go through very easily, no problem. And then you can raise money for your soccer matches, and you have your bank account and corporate personhood in Egypt, just like you would here, no problem. But if you wanted to start a Center for Human Rights, then suddenly the paperwork would never be approved. It was very obvious what was going on. Everybody knew. But narrowly speaking, each decision could be defended. And this is an argument that is very powerful in all areas of administrative law and has become a very important issue now, which is, should lawyers and courts just look at the four corners of the document? Or do we get to look at the bigger picture of where that document fits in the world? That's a very big issue right now, because when the way in which you can defend each of these individual actions is by narrowing your focus smaller and smaller. So hey, that's no problem. Like, you know, doesn't the IRS sometimes scrutinize some applications? Yes, they do. So why is it so different when Egypt does that? All right, one other thing. When I was in Egypt, I worked in setting up refugee legal aid, and I represented people who were not applying to the Egyptian government. They were applying for refugee protection from the United Nations. And the United Nations was doing the work of the US Asylum Office, basically, refugee status determination. And what I initially discovered and what really enraged me, and the reason I went back to work there, was that they didn't follow any semblance of due process whatsoever. The first case I worked on of an Algerian refugee was initially rejected on a slip of paper with a number crumpled up, handed through a crowd of people at a fence, and it just scribbled in handwriting REJ. That's how he found out that they had denied his refugee application. They didn't allow lawyers into the interviews. They didn't provide reasons for rejection. You couldn't see the evidence that was used in your case. And that was the United Nations. So that was in 1998. And that taught me something else, which is that the good guys don't always do good. And no one actually likes to be held accountable. No one actually likes due process, including the people who are there supposed to defend people's rights. But there were other things about the UN which I think are really important, which I noticed that the Egyptian government, which was often a bad actor and was at best, on its best day towards refugees, would apply a policy of benign neglect towards refugees. UN officials, being diplomats, were often willfully blind to understand what was going on. They would come out of meetings with Egyptian government officials and would sort of repeat back without any skepticism whatsoever that what the Egyptian officials had told them. We really want to set up a refugee system. We're just trying to work through these couple problems, right? We're almost there. And that dialogue went on for 2 decades. They're always almost there. And they would always, the UN officials always, most of them anyway, there are a few would say that with a raised eyebrow, but most of them would repeat that back with sincerity, as if they believed what they were just told. Unwillingness to see racism on the streets, which was obvious. The refugees were telling us about it all the time. What would happen to Sudanese refugees living in slums in Cairo. But the UN did not want to hear it because it could not fit very easily in any diplomatic communication. So it would be better not to acknowledge it. And then finally being far too easy with compliments. UNHCR is notorious for this, or should be notorious for this. If you merely meet with them, they'll say you're wonderful quite often. So for example, in January this year, the UN High Commissioner said, Egypt has been a lead example in the region in hosting refugees in an urban setting and providing services in the health and education sectors on equal footing as Egyptians. I'm not sure that any of that has much content. And if it has content, I don't know that any of it is true. But again, they move the benchmarks, basically. If you simply allow us to operate and meet with us, we will say, hey, you're doing good. But too easy with compliments. So let me end there for my detour in my early part of the career. But keep those ideas in mind. I'll come back to them. Now I want to talk to you about Las Vegas. Okay? And then I'll try to weave this all together. So I will not, because it's against policy in Las Vegas, to ask you if you've been there. If you have, it's privileged. And I live there, I will admit that. When I went for my job interview at UNLV, on the plane I got on, there were people already drunk. I now see that as normal when I fly home from a trip. So I want to actually tell you about Las Vegas as a city of 2 million people, where real people live, and we take our kids to school in the morning, and go to work and do things like that. But also as a city on the front line, because very much in the America's war on immigration, we are the front line, but it's the front line that you don't see and don't hear about as much. So to introduce you a little bit to Las Vegas, I want to tell you there's this really fascinating data point that USA Today has produced called the Diversity Index. I hope there's no demographers here because I have no idea how good this is, but I think it's at least as a rough estimate, it colors something really interesting. The Diversity Index, they do it by county, not by city. The Diversity Index is 0 to 100. And the idea of this, at least as I understand it, is that what are the odds that if you take me and one other randomly selected person who lives in this county, what are the odds that that other person will be different ethnically or racially than I am? If it's 100, then it's for sure that the person will be different from me. If it's 0, then the person is going to be another white, I don't think just white man, but another person will be basically white if it's me, right? That's what the diversity index is. To give you a sense of what this means, the US National Diversity Index is 58. So what that means, taking the US as a whole, for any one of us, you don't have to be white for this to apply. The chances that another randomly selected person in the United States will be the same race as me, race and ethnicity as me, is basically 50%, okay, roughly speaking. I'm a lawyer, so all numbers are rough for me. To give you another sense, Wayne County, so I don't have the city of Detroit, but they have Wayne County, is 61. So Wayne County is actually pretty close to the national average on diversity. Washtenaw County is 48. I have a feeling, of course, if you were to narrow that down, because of course there is not consistency in the United States about the difference between a big city and the county. So this is not perfect, but again, I'm a lawyer, so it's the best I can do with numbers. But to give you, so the nation is 58, let's say Detroit is roughly 61-ish. Clark County, which is Las Vegas, is 72. So basically in Las Vegas, there's a 7 in 10 chance that a randomly selected person will be different from me. And that's basically the same as the city of Chicago, or same as Cook County. Most of the biggest cities in the United States are in the 70 to 80s. So New York, LA, they vary a bit. Las Vegas is not the most diverse, but it's extremely diverse. What's really important to know about that, so we are a very, very diverse place in Las Vegas. But it's also very important when we look at the effect of immigration policy, why we're so diverse. Because if you were to say, so Las Vegas today is roughly just as diverse as Queens, New York, or Brooklyn, New York, except that there's a big difference about Brooklyn. Brooklyn was just as diverse in the 1920s when my great-grandparents lived there. Las Vegas barely had anybody living there at that time. But in 1980, so during my lifetime, the diversity index for Las Vegas was 34. So in 1980, there was basically almost any other person I would meet in Las Vegas would be another white person like myself. Now, we're a majority minority city. That's a very rapid period of change. And that is why immigration policy is so important in Las Vegas. So a little tidbit about also what's happened in terms of migration flows. It wasn't really described this way at the time, but basically in the 1990s and very early 2000s, the US experienced a mass migration, mostly from Mexico and from Central America. And it wasn't described in those terms. In fact, it's interesting in terms of the way there's discussion of a border crisis now with actually numbers that are very significant, but actually smaller. That it wasn't described that way at the time. But just in the year 2000 and 2001, which are the two biggest years in modern southern border history, Border Patrol apprehended, so these are the people caught, 2.8 million people over a 2-year period. That's the ones they caught, right? And so by definition, because people were coming into the country, what we call in immigration law, entry without inspection, they were trying not to be caught. So we only measure the rate of flow by those who fail. DHS, now again, I started by saying there's problems with government statistics, so I don't know the reliability of this, but that's the issue. I have nothing else to go on. They estimate there's been a whole lot of investment in border enforcement over the years, that today they catch about 70 or 80% of the people who try to cross, but they estimate that back then, in 2000 and 2001, that they think they only caught about 30 to 35% of those who tried. So that means that in just 2 years, 2000, 2001, if they're right, again, law professor math, but if they caught 2.8 million people, that means 8 million people crossed successfully. And a lot of our undocumented population in the United States today comes from that group. At that very same time, that same era, I only picked on 2 years, Las Vegas was booming. So the population of Las Vegas doubled from 1990 to 2010. So that means tons of jobs in Las Vegas, construction workers, cleaners, huge expansion. At the same time, there's this mass migration from Mexico and Central America. And so it is not surprising that many of them ended up in Las Vegas. And the result of that today is that Las Vegas is essentially tied with Houston, with another city that boomed during this era, for having the highest per capita population of undocumented people. When you were in Las Vegas, approximately 1 in 14 people you see is undocumented. If you come to Las Vegas and you're staying in the Strip Hotel, you will almost certainly have your food cooked by an undocumented immigrant. Your room is likely to be cleaned by someone with temporary protected status. I'll come back to them in a minute. Our houses are built by undocumented immigrants. The restaurant industry cannot function without undocumented immigrants. Cleaning at every level of cleaning, ranging from house cleaners in suburban neighborhoods to the industrial cleaning that keeps the fanciest casino resorts sparkling, all done by immigrants. And just to highlight that issue of cleaning and of the degree to which Las Vegas is an immigrant city in which immigrants are woven into every aspect of our life, we unfortunately, we experienced the largest modern non-government mass shooting. That's a very important phrasing there. What we know as the October 1 shooting in 2017 at Mandalay Bay. Undocumented immigrants were among the victims. Not, so far as I know, among any of those killed, but they were shot at and injured. And we actually represent a few of them in our clinic. And they were cleaning, specifically the ones we represent were cleaning the porta potties at the concert. They were employed by the contractor doing that. If I made up that as a job, it's almost too stereotypical as the ultimate undocumented immigrant job, cleaning literally the toilets for Americans at a concert, but it's true. We have documents to prove it, but that's natural, and they were shot at along with other people at that event. And that is actually, in many ways, perfect because it illustrates the degree to which they are very much part of our city. They are not a separate group. I also want to point out, in addition to those more sort of stereotypical and common jobs for immigrants, that we have undocumented students at the law school where I teach. Not just undocumented students, but many, even more, children of the undocumented students, because this migration actually has slowed down quite a bit. So most undocumented immigrants who came in that period, if you came in that large group in 2000, well, now you've been in the US for 2 decades. And in fact, the average undocumented immigrant in Las Vegas, the typical person would be from Mexico and has lived here for more than 15 years. I usually tell everyone that most undocumented immigrants in Las Vegas have lived in Las Vegas longer than me. And their children are now my students. So the trouble that is important to understand, and it gets to the issue of law, is that despite this incredibly high level of integration, that they are an inexorable part of our community, they have no more legal rights now, essentially, than they did on the first day when they were walking across the river. The fact that we see them on graduation day at the law school, hugging their sons and daughters, and this is an amazing thing. Some of our students graduate from law school, and they're the first people in their families to have graduated from high school. But their parents, for all that, get essentially nothing legally, no substantive right to be here, and most of that population are all facially removable from the United States. They're all facially deportable if they survive in the U.S. simply out of either discretion, which no longer is exercised, or because of simply the limited resources of immigration and customs enforcement. The fact that they are actually so vulnerable is a failure of politics in many ways. In June 2019, this year, CNN took a poll and asked people if they supported mass deportation of all undocumented immigrants in the United States. Only 15%, 1-5, said yes. So actually, that's amazing, because remember, given our partisan breakdown, you'd think that at least 30% might support that. But no, 15% said yes, and there were only 4% undecided. So America has decided on this. Long-standing undocumented immigrants with no criminal record, people don't support their deportation, but we deport them anyway. That seems to be some type of failure. Let me talk about TPS and temporary protected status and DACA. Now, DACA is in the news quite a bit, but temporary protected status a little less so. Combined between DACA and TPS, if the Trump administration has its way, we will make almost 1 million more people undocumented and vulnerable to deportation. And those battles are percolating through the court. Of course, DACA, the argument is next month at the Supreme Court. In Las Vegas, according to the Center for American Progress, there are 5,700 Salvadorans, just Salvadorans in the state of Nevada with temporary protected status. They have 3,800 U.S. citizen children, and they have lived here for an average of 24 years. All of them might be undocumented and vulnerable to deportation maybe by the end of next year. 30% of them, by the way, work in the hospitality sector, and that number, Salvadorans are the largest group. We don't have as good numbers on Hondurans, Nicaraguans, and Haitians, among other groups that have been threatened in that. And this really illustrates a legal problem, right? The T in temporary protected status is temporary. It's the first word. On the legal theory, it was always supposed to be temporary. It was never supposed to last forever. So the fact that it might finally be brought to an end, in a cold legal analysis, well, maybe that's fine. But it's clearly not fine for a community or a family who've been living here for basically a quarter century. There's been a great deal of national litigation about immigration since 2017. And that litigation is what has kept DACA and TPS alive until now. That is why people still have employment authorization. Of course, though, that might end next spring. But the fact is that for all the heroism of the airport lawyers and the photos that we saw from the initial Muslim ban back in January 2017, most of this litigation has in the end failed to stop Trump administration policies. The Muslim ban is the leading example of this. Version 3 is still being applied with all the problems essentially that were predicted. Probably most disastrously, the Remain in Mexico policy was not even enjoined. The usual pattern we have seen is district courts enjoining policies, and then eventually the Supreme Court reverses the injunction. The president himself has boasted about this. But on the Remain in Mexico policy, it wasn't even initially stopped. It was put into place. And this is a policy that has already very clearly led people to die and be raped. And that's just being implemented. And there are, I think last figure I saw, more than 60,000 people stranded in Mexico because of this policy. There are new cases, of course, that are just starting, the public charge rule, new rules on asylum. But again, we don't know what will happen with any of them when they finally percolate up. The only success is the census case. And that's only because the government had a timeline. So it was boxed between a court and a timeline. The cases that have been initially successful have not been successful for the most part on what's really in front of most people, the basic cruelty treatment of a fellow human being. The kids in cages, right? What has mostly been successful are process arguments, that it was arbitrary and capricious. The Muslim ban, again, is exhibit one of this. The problem for many people with the Muslim ban is that the Trump administration rushed it out. So they didn't let the good lawyers at DOJ polish it a bit more before the first version. So they had to get to version 3, and then that finally withstood judicial scrutiny. There's been no victories on the substance of migrant rights. And this should not be surprising if you look at the state of immigration law before 2017. The progress, to the degree that any had been made, had been on due process, procedural rights. The Supreme Court had begrudgingly, in a split decision, acknowledged that when an immigrant is locked up, that their liberty is impaired enough that procedural due process actually matters. And that was acknowledged only grudgingly. And it's common now when someone is being deported that Department of Homeland Security officials will say to defend their deportation, well, they had their due process. A big issue is whether animus matters. Does it matter that these policies were put into place by politicians who have been pretty open about hatred and contempt for certain racial groups that seem to be the only most obvious motive for particular policies? Or, as the Department of Justice is more likely to argue, should the court limit itself to the four corners of the document? So if the document itself is free from any epithets against darker skinned people, does that make it all right, even if it's pretty obvious to everyone where this policy is coming from? We have due process. The rule seems to be that we can inflict a great deal of cruelty on people so long as you just go through the right process first. And the Trump administration has made a mistake of just rushing too much to get to the cruelty. So the process itself is a shambles in many ways. You have a situation where kids go to their deportation hearings without being given lawyers. You have also adults without lawyers, which I think is only marginally better than kids not having lawyers when they are detained and locked up. That's normal. That's the normal process. We have judges without independence. Immigration courts are not real courts. They're employees of the Department of Justice. They work for the Attorney General. Removals are based entirely on hearsay. Hearsay is admissible in an immigration court. We depend on it in asylum applications. But there's a rule in asylum cases that if you present hearsay but better evidence would have been available and you fail to produce it, that can be held against you. But not for DHS. So the removals are based always on hearsay documents. They could produce their own officer to defend it. That is their employee, but they're not required to do so. The backlog in immigration courts has now passed 1 million, which is pretty astounding. That means roughly like 1 out of every 350 people living in this country actually has a pending case in immigration court. And of course, they're not actually immigration courts, not only because they're not really courts, but because they also don't handle immigration. These are deportation tribunals. They actually don't even have jurisdiction over most immigration questions. And so they can actually be forced to order someone removed when there's actually a pending visa somewhere else, the application that's likely to be granted, and the judge knows that. So, but at least there's some process. This is sustained by a whole set of doctrines that we learn in law school. and that are very challenging. We have Chevron deference for deference on questions of law. So the courts are supposed to give deference to the Attorney General on interpretations of immigration law. We also, if it's not a question of law, then there's there's deference on findings of fact. That can only be overturned if it's not backed by substantial evidence. If you haven't taken civil procedure and administrative law, just trust me, deference basically hard to appeal these decisions is the basic idea. An overriding document is the presumption, overriding rule is the presumption of regularity, the assumption that anything a US government office issues should be assumed to be a reliable document unless proven with quite a bit of evidence otherwise. It's a natural rule, and actually in a healthy government would be a perfectly reasonable one, but as I mentioned, it's a concept that's being under challenge right now. We've seen that government documents are maybe not so reliable. Government statistics are maybe not so reliable. They may simply be a partisan position. And especially in the field of immigration, deference to the executive. This has been extremely important in immigration, and means that deference that would exist in any other area of administrative law is often even stronger in immigration. And critical in all this is the issue of should a court look beyond what the government is saying. Let me give you an example, beyond the four corners of a document. One of the things that we've yet to see enforced, but it's obviously coming, the government has been working on agreements with Central American countries that anyone who passes through Guatemala, for example, will not be allowed to seek asylum in the US, will be sent back to Guatemala. In January through November 2018, Guatemala received 262 asylum applications. 262. I run a clinic in Las Vegas where it's two fellows and myself. We have roughly the same caseload as the entire country of Guatemala, right? That means on the one hand that I overwork my attorneys a little bit. On the other hand, it means it's a farce, right? But the State Department lawyers, if given time, if this is not rushed out, will produce a document that looks like it meets legal requirements. Should a court look beyond that, or should they look only at the four corners of the document before signing off on this? Plus, it will be by nature reviewing the rights of people who have no rights. They haven't entered the US yet. So should a court look at it at all? In Las Vegas, where you probably have never heard of an ICE raid, nobody has, we have an ICE raid every day in our jails. The number of new deportation cases has more than doubled since 2017. Close to 400 people now are entering the deportation process in immigration court every month. If that were a raid conducted by ICE, it would be on the evening news nationwide, but instead it happens quietly through our jails. The police departments hand people off. It doesn't, again, much like what I learned in Egypt, it doesn't have to look thuggish, right? It doesn't have to have the video of a roundup that is scary to people and disturbing. It can happen through the machinery that we've already built. And then the compliments that come too easily. One of the main portals to the deportation process in Las Vegas is the Las Vegas City Jail, which is run by the city of Las Vegas. Just this past week, Mayor Carolyn Goodman, who's the mayor of Las Vegas, appeared at a DACA renewal clinic and had her photo taken, which makes it look to the world like she supports people with DACA. But she supervises a jail that next year, under the policies that right now she supervises, might hand those same people over to ICE. That is very similar to what I saw at the UN, compliments being given away too easily, in this case by immigrant rights activists who perhaps pose for photos a little too easily to give the appearance to a politician without that gesture being backed by actual policy. So something very ugly can happen here in the US. None of it, though, should be a particular surprise. Of course, Hannah Arendt warned us about this, that the problem for someone who's not a citizen is that they don't have the right to have rights, and that's the basic problem of immigrants in the US, that they have a procedural right and no substantive rights. I think that's also a bit too simple. We had moved past that to some extent. A procedural right to due process, combined with a government run with a minimal sense of decency and which knows how to use its discretion, can protect many people, but we now know that that protection is unstable. courts have a real struggle. We need rules. We don't want courts just making policy decisions. And so that is why courts have these rigorous analytical frames. But of course, they can also be easily manipulated and can lead judges to not see what is right in front of everybody else's eyes. So let me leave you, I think I may have spoken longer than I was supposed to, but with a couple thoughts on what needs to be done. First, because procedural due process is virtually the only right that actually has been protected at all and imperfectly, we need to bolster that process, right? So there's been a lot of work at the grassroots level locally, expanding deportation defense for people facing deportation, often using local funds and philanthropy. The state of the art are bond funds. So many cities there are private foundations and funds you can donate to that is used to get immigrants out of detention, because bonds in immigrant detention are higher than they are in criminal justice. So whatever problems we have in the criminal justice system, just magnify that for the immigration system in terms of the effect of cash bail. For courts, there is a tool that we actually already have, but I think our current judiciaries, many judges are very reluctant to use, which is look at motive. So many policies that are facially acceptable elsewhere, if we know are enacted because of racial animus, which we've got a lot of evidence for with this particular administration, we look at motive in court all the time. That is not an earth-shattering or radical thought. We know many things that are perfectly legal for one motive become illegal for another motive. The reluctance of some judges to apply that to the president and to the administration is troubling. Probably because they legitimately worry about treading into partisan rhetoric, but sometimes if the evidence is overwhelming enough, we ought to be able to look at it. That's a real problem we have to address. The presumption of regularity of the government has to be re-examined. Perhaps deference should not be presumed. Maybe it needs to be earned, and maybe it can be disearned. I don't know if that's a word. But I want to say something else about the legal profession that we have to look at, that a law school has to look at. Why is it prestigious to go work for government agencies per se? I know this, by the way, in faculty hiring. It's a very prestigious thing if you've worked at if you've been a government lawyer. And many of those are very good, essentially very good legal practice areas that deal with really challenging issues. But should we presume that anyone who works for the government, it's a prestigious thing to do? It motivates many, many smart people to go into work that may not live up to the ideals of our profession. That's something I saw in Egypt, and I believe may be happening here. I know that there are people in the government who will defend these policies because that is their job. Should we consider that always prestigious, necessarily relative to other things? It is deeply embedded in our profession that we do, but it perhaps needs re-examination. And finally, this is my only bit of optimism. Substantive rights matter. We haven't recognized them for immigrants very much. We've relied on the decency and discretion of government officials to avoid the maximum level of cruelty. We now should be able to see we cannot rely on that. If there is hopefully some degree of consensus that, for example, the epitome of recent policy, kids in cages, if that is wrong, maybe we need to articulate, well, what's wrong about it? Because obviously it's not obvious to everybody. And maybe from articulating what's wrong with these things that people have been rightfully horrified by, we might be able to articulate actual rights for migrants. Because if only 15% of people want, say, my neighbors in Las Vegas to be deported, but they are legally deportable, maybe we need to turn that public sentiment into a substantive right, not simply rely on process. So I will stop there, and hopefully we still have some time for questions. Yes, ma'am. And are we supposed to usually, yeah.
Well, the question of, or the use of the term due process, or procedural due process, is very common in legal practice.
Right.
It seems to be, though, the idea of of due process seems to be a window through democratic institutions that dictators can pretty readily penetrate. And also, the protection of due process seems to depend on the integrity of public officials. So, is due process so specific to particular areas of law that it would be difficult to protect by legal stipulations? Is that one of the problems of legislatively protecting due process?
Yeah, I think that's a really good question. That due process is very easy to get around. You get due process for a parking ticket as well as for a death penalty case. It's all due process, it's just a different level of process. A big problem actually is excessive legal formalism rather than focus on what is actually at stake. So in immigration and deportation specifically is classified as civil, not criminal. And it's because of that classification that you get much less process. So you literally actually get more process for a misdemeanor arrest that has relatively few consequences for a traffic ticket in Las Vegas than you would in the Las Vegas immigration court. You actually get more of a hearing. You can call the officer in and cross-examine them, but you can't do that if your entire family's life is at stake and you're detained by the Department of Homeland Security. And that's because of a formal legal categorization, not because of functionally what is at stake.
So is it feasible to legislate to protect due process?
Absolutely. So actually what's interesting in immigration is that most due process advances for immigrants in the U.S. have actually more often come through the political branches than through the courts. There have been a few victories in courts. The Zadvidas case, which had to do with people detained essentially for life, was one of the few victories in this area. But even the creation of the immigration courts was accomplished more through the political branches. So yeah, Congress, and there are proposals to do this, and there are more now than there used to be. At least, on the shelves, that if the political will is there, can be pulled down. It's much more on the radar screen and on the agenda to fix the system than it was even 5 years ago.
Hi, thank you for that really interesting talk. And I was intrigued by what you said throughout about procedure, but especially at the end, the idea of having to articulate, it seems crazy that this hasn't already been articulated in a way that can be, that has been successful in courts in the US, that obviously the kind of cruelty done against immigrants in so many situations at the border right now, but the kids in cages and many other situations is inhumane and is cruel. And I'm wondering what kind of the other side of that is not only the legalization of those situations, but also the criminalization of kindness. So the criminalization of people who are helping immigrants, for example. And there, as I'm sure you know, many cases that are pending right now of people in those situations. And so I'm wondering, when you talk about articulating what's wrong with these situations on both sides, what kind of language might be available that has not already been used? And I was particularly curious about the availability, because there's so much articulation of these kinds of situation and what's wrong with that kind of cruelty in international human rights laws that you can correct me if I'm wrong, but I think started to be used much more in immigration cases in the US 5 years ago, over the last 10 years, and now seems to have been shut down. So I'm wondering if you can talk about that, whether there's any possibility that language can again be useful, and if not, if you have to rely just on US constitutional law, are there precedents for those kinds of arguments having been made in the past that has since been shut down?
Yeah, I think, there's a lot in that. That is basically the legal problem, which is that if families should not be separated, or if you want propositions that I think shouldn't be too controversial, or kids shouldn't be locked up, well, what's the basic question that you learn in first year law school? What's your citation for that? What's your what authority do you have for that? And that is where things get disappointing. It's not obvious in U.S. law what your citation is to that we just shouldn't do this to children. Well, where is that exactly in the Constitution? We end up coming back, therefore, to the Flores settlement, which is this settlement that was as much a political product as it was a legal product. And of course, they're working on overturning it through regulations. So again, the arguments in court are not even directly about the substantive issue. Human rights law might have something to say about this. Very difficult in our legal culture in the US to invoke that. Only some judges are receptive to it. And even when receptive, you often have to find a hook through it. Is it implemented through legislation? There's something called the Charming Betsy doctrine that we can use it to interpret our own legislation. But I also have to note, migrants are not well protected in international human rights law. Most of the undocumented immigrants in Las Vegas are not refugees. And so they wouldn't fall under the mandate of UN High Commissioner for Refugees. There's no inherent requirement for a government to accept people from a foreign country just because they're there, even if they're there for 25 years. You can construct arguments stemming from other rights, but they will find but that's not well accepted by even esteemed democracies. So that is very much the problem, that governments have not been willing to grant rights to migrants per se just because they're people. Refugees actually stand out as kind of the island in this very harsh sea, which is why we have so much fighting over the refugee system. So I'm not sure that's a direct answer to your question, but I think we may actually have to articulate new areas of law, but that can be done through legislation.
Thank you. Sylvia Pedraza, professor of sociology here at Michigan, and a student of immigration.
Hi.
I think my question follows up well from the points that you have just both touched upon, and that is, you have just said most of the immigrants in Las Vegas are not refugees, they're economic immigrants, and therefore they're not protected by refugee law. But actually, refugee law recently has not been protecting people at all. I mean, I think immigrants have wised up to the fact that they would do better to claim that they are refugees, and they come and they want to claim asylum, and they're not being allowed to claim asylum, and we're in fact actually sending them back and insisting that they have to apply in the countries that they're trying to leave from. But one of the basic things that I understand about refugee law is the non-refoulement principle of not returning people to the places that they're trying to leave from, because that's dangerous. But we do it all the time. I mean, we had a wet foot, dry foot policy in place for 20 years in this country, where if a little boat with people from the Caribbean was found at sea, the US Coast Guard interdicted them and they would send them back because they were wet. If they were dry, if they arrived at land, then we accepted them. But there's enormous arbitrariness also going on with refugee law. And I think that immigrants have realized that they would do better to request asylum, but we're not going to give it to them. That's what I think.
I appreciate that. I agree with you that refugee law has eroded, implementation of it has eroded considerably in the US, which, while never having a perfect system, not too long ago had one of the world's best refugee systems, subject to many caveats all the way along. And yeah, we are violating the principle of non-refoulement, and that is why the fact that courts have not stopped the Remain in Mexico policy is so alarming, because that's actually an area where the Supreme Court has actually already recognized that an international treaty has bearing on how we should apply our own legislation, and yet still courts have allowed that to be implemented. I'm not sure that immigrants have wised up per se. I think that immigrants who have fled violence have always sought refugee protection, and the people from Honduras and El Salvador and Guatemala at the border are fleeing genuine violence, and that's why they're seeking asylum. But we are denying it to them and not even letting them apply. I think to come back to the previous question, there are a couple things that that could be, one thing that courts could be asked to do is value people's liberty much more. The way these questions are often analyzed formalistically is that, well, this person has entered the country, we don't know if they're allowed to be here, therefore we have to detain them, therefore the default is detention, we have a massive detention complex. What if we started instead from the principle that should not be so radical in this country, that individual liberty matters, that the default should be freedom, that you are not locked up, And that, sure, the government has a legitimate reason to detain some people and imprison some people, but the burden really needs to be on the government to explain why that is necessary, bring some type of proportionality tests into our enforcement of immigration law, so that we look at what is a minor civil infraction that occurred 15 years ago and consider what is the human effect of enforcing that now. That could reshape things. And those are principles that we have had in our law in the past and are still there, but they don't seem to have very much force and implementation in the courts.
So I'm curious how you envision the substantive rights for immigrants will be created, potentially, and like what sort of activism you see as most effective.
So actually, I think the gentleman's first question actually about legislation is probably the most natural answer to this. There has been, look, this has become very partisan in the US, so largely movement within the Democratic Party. There's been a significant shifting in the agenda about immigrants and about immigration policy over the last decade. And that actually gives me some hope that that could eventually lead to legislation that would actually enshrine some rights that we don't have right now. So for instance, the idea that we should not necessarily deport everybody who is unlawfully present, that's now essentially mainstream politics in one of our two major parties. 10 years ago, that was not so. 10 years ago, the DREAM Act didn't even get all Democrats to vote for it in the US Senate. There has been some movement there, but I do think what needs to be pushed to some extent, the primary election right now has been a forum for some of this to be discussed, at least at a very superficial level, is that there's widespread horror at things like kids in cages. The next step, though, is to articulate, well, why does it horrify you? I actually think that there's a opportunity that the Trump administration has opened and that people are more open to hearing about cruelties that immigration lawyers have known have always been in the system now are easier to get people to hear about than before, because when it was people, whether it was Democrats or Republicans, when there was a different type of person leading the government, the problems in the law that we would see often seem more theoretical, but they would never actually do that, right? So that doesn't have to be at the top of our agenda. Now we know if they have the power to do it, someone will. So I actually take some hope in that. If anything good comes from this, it will be that people can now see the need to articulate these rights in a way that they didn't beforehand. Yes.
I wonder if I could take you back to your Middle Eastern experiences and
Sure.
ask you if international law is there greater receptivity in those countries to use international law in these matters? And would you maybe comment also on Europe, which would seem to be the place where you'd have the most receptivity to international law in the legal systems?
Sure. In certain ways, international law does have more currency in the Middle East than it does in the United States. If you go into a US court and cite international law, a lot of judges will immediately, invisibly wince, if not make a negative remark. But at the same time, of course, human rights in the Middle East is not well implemented, to make a modest proposition. And so even while there's perhaps more discussion and discourse about international human rights, that is in many ways because people are reaching for something to use to get something that they do not have. When I lived in Jerusalem, I had a Palestinian taxi driver, and one time only that I ever told someone I didn't know that I was a human rights lawyer. The taxi driver said, well, why are you here? Do you see any human rights here? So I think there's more discourse, but at a certain level, a body of law that can be enforced is better than one that is theoretical. So while I wish that we had more implementation of international human rights law, I admire the fact that you can actually go to district court and get an injunction to enforce the First Amendment if your book has been censored. Whereas in Egypt, you probably would not, even though people will talk about it more. Europe, though, is actually probably a better illustration of what I'm talking about the trouble that narrow legal frameworks make, which is that you're right, there is both their enforcement mechanisms through developed judicial systems, and you would think the law would matter more. But government lawyers have been mostly very successful in finding ways to craft policies that escape the lenses through which the courts will use. So at lunch today at the law school, I got to hear a presentation about the Dublin Conventions, which is this convention that determines, in theory, where your asylum case should be heard in Europe. And basically the argument of the speaker was that, narrowly framed on its face within the four corners of the document, the convention should be legal. But as applied, it's completely illegal. I don't disagree with that, except that I think that the fact that that's how it would happen was obvious from the beginning. And this is the problem with when courts only will look at the four corners of the document rather than look at what we know are the motives of the policymakers enacting that. And I think what's happening a lot is it's actually the same as what happened between Muslim Ban 1.0 versus Muslim Ban 3.0, which is that there's a policymaker who states, I need to accomplish this, and it might not be very elegantly stated. And then they have a whole team of lawyers who will work that up and produce a document that can withstand judicial scrutiny, and they'll produce that. The mistake of the Trump administration with Muslim Ban 1.0 is they rushed it out without letting it run through that filter. The Dublin Conventions, that was written by excellent foreign ministry lawyers who knew how to frame a document that on its face would not narrowly violate any international treaty, but everybody knew this was never going to work as stated in practice, but it would be hard to do anything about it.
Hi.
Hi.
My question would be, has anyone figured out the cost, just like the prison system, it's a waste of capital to incarcerate people. For the immigration system, it would seem like stupidity to pay, $40,000 a year when you could send the kids to college.
I don't disagree with you. The cost is very well known, and the cost is a plus factor for the government and for an industry. So the immigration detention is very, very linked with the private detention industry. They lobby for it. They actually have a guaranteed payment, effectively, a certain number of beds a night. So we detain 60,000 people every night in immigration detention, federal immigration detention. Some localities have gotten into this. The city of Henderson, Nevada had expanded its jail to get a contract from ICE to detain people. That's where a lot of our clients sleep at night. And so they know the costs very well. It's in the federal appropriations every year. And for those who back it, the cost is worth it because there's an industry, and the industry likes to expand.
Then we gotta pay for it.
We do pay for it. We do pay for it. But then, of course, there are many people for whom it seems natural, hey, these people have come across the border, of course we have to detain them. And so it goes.
Maybe one last question.
Yeah, one of the things I noticed in locally is that they came in and they arrested a father of two kids that lived in Ann Arbor.
Yeah.
But almost immediately, and I forget exactly where it was, but within 2 days or 3 days, they had moved him from Ann Arbor to Flint, I think, to Louisiana to Youngstown. Are the courts doing anything about it? The only reason you do that is you try and lose people, as in they can't find a lawyer, or the lawyer can't find them.
Yeah.
Are the courts doing anything on that?
No. And again, that would actually be a natural place to have the courts step in. But the courts have allowed the Department of Homeland Security essentially total unfettered discretion to decide where to detain people. And that does lead people to lose their attorneys because they're moved from Los Angeles to Arizona to Tennessee to Louisiana. I have a client in Louisiana myself right now. So the courts have not blocked that. So you can go in, you could file a habeas petition and say, this deprives my client of their due process right to access their attorney. That will lose, unless a court is willing to go farther than a court's gone before. And it would be a natural place to step in. Just to even add to that, I was recently in the Las Vegas Immigration Court. they don't even bring people from the local detention centers to the court. They're on video screen, which has a whole other set of problems. There was a person on the screen, did not have a lawyer, talking to the judge, and the judge was very politely saying, this is your hearing. This is your chance to ask questions. Every question the person asked, the judge said, I can't answer that. You'll have to ask DHS. DHS has a lawyer in the room. He wouldn't answer anything. One of the questions, the court was requiring, the immigration courts require a written motion for a bond hearing. In criminal court, the Las Vegas Justice Court, you can just make an oral motion. In fact, an arraignment is there's an automatic bond hearing. Immigration court, if you don't speak English, you still have to write a written letter to the court, and then you have to mail it to the court. And he asked the judge, well, Your Honor, I actually filed motions to the court before, but I don't know where it went because they moved me. I was from a different detention center, and my mail's not being forwarded. And the judge looked a little surprised and then asked the DHS attorney and said, is mail forwarded when you move someone from one detention center to another? And the DHS attorney said no. And the immigration judge said, I'm very sorry, there's nothing I can do about that. But the person is not even, it's not like someone choosing to move their apartments. The government is moving them from one detention center to another. They don't have a lawyer. They're representing themselves, and the government's not forwarding their mail from the court. So it is a process. I don't know that it's the process that's due, even just on process terms.
All right, on that note, please join me in thanking Professor Kagan for this powerful, somewhat depressing presentation.
Thank you very much.